all references to value in relation to theft offenses must use the fair market value test. So this is also consistent with the Judicial Council of California jury instructions, in particular instruction 1800, which says quite clearly that petty theft and larceny are defined by 44, and 44 is the provision of California law that says value is fair market value. I think the right interpretation of the CalCrim instruction on intrinsic value is intrinsic value sort of sets the floor. There has to be some intrinsic or fair market value. It can't be completely without value, but it doesn't have to be anything more than a penny or even a tenth of a penny. There has to be some intrinsic value. But I think the key case for us is People versus Simpson. In People versus Simpson, a defendant in the case requested an instruction, and I'm reading the instructions requested from the case.
What's the site?
It's People versus Simpson, 26 Cal App 2D 223. People versus Simpson, 26 Cal App 2D 223. And the quote from the defendant's requested instruction is, "The only test of grand or petty theft herein is confined in that portion of section 44 of the Penal Code, reading as follows. In determining the value of the property obtained for the purpose of this section, the reasonable and fair market value shall be the test." And the key line from this requested instruction was or petty theft. The only test of grand or petty theft is the reasonable and fair market value. The Court of Appeal wrote in reversing the trial court's judgment that, quote, "the requested instruction should have been given." It did not say the requested instruction just on grand theft, or the requested instruction just on petty theft, but the entire requested instruction. And while the Court of Appeal did uphold partially the conviction, it reversed the conviction for grand theft. It upheld the conviction on petty theft only on the grounds that the prosecution did show evidence of some fair market value. It didn't show any specific fair market value. So I think People versus Simpson makes clear that the requested instruction should have been given, and that requested instruction included a definition of petty theft that required fair market value. Finally, I want to point out just 3 doctrines of statutory construction that are potentially relevant in determining whether the instruction in this case should include fair market value. One is the doctrine of absurd results. Tolomi Jobs and Small Business versus Superior Court held that interpretations that lead to absurd results are to be avoided by judges. And here, a definition of intrinsic value that is completely subjective or based on the sentimental or arbitrary valuations of an owner could lead to absurd results, such as someone just arbitrarily and delusionally thinking a piece of lint is extremely valuable, and suddenly people can be prosecuted for theft for taking lint that objectively has no value at all. The second doctrine of statutory construction is the doctrine of constitutional doubt, which holds that courts should construe statutes so they do not violate the Constitution where it's possible to do so. And one of the big problems with a completely subjective or arbitrary test for value, Your Honor, is that it's vague. It's very hard for anyone to have notice as to what could be theft and what cannot be theft, and it's entirely dependent on one person's whims. If that person just happens to have strange feelings about lint or sick chickens for that matter, suddenly it could be theft, where before it was not. And I think the Constitution doesn't allow, from a due process perspective, that sort of arbitrary distinction based on the delusions of an individual person who happens to be the owner of property. Third doctrine is one we all know, the separation of powers, which holds that statutes must be applied so that each branch of government maintains a separate sphere of power. And because 484 was written and passed by the legislature, which has the rightful role to write the laws, I think the language of the legislature's instruction in 484 should supersede even any judicial case law. And so for those 3 reasons, I think the appropriate interpretation of intrinsic value, along with People versus Simpson, which upholds the notion that intrinsic value should include fair market value, we move to that for any instruction, either before the presentation of evidence or at the close of evidence, any instruction involving intrinsic value should include the test set out by Simpson and by Section 44. And the last point I'll make is the people actually conceded this in one of their own motions. The people's motion in limine filed on March 1st, and they actually had a prior motion in limine that made the same concession and argument. And I'm quoting here from their motion in limine. "Should the court determine value is not established, the fair market value is the test to determine value." So this is in their own briefing. They filed twice, once in the original motion, second in their amended motion. So I think there's agreement between the 2 parties. There's agreement in the case law. There's agreement in the statute. And there's agreement, hopefully, that there are serious constitutional concerns to the extent we determine intrinsic value by something other than the fair market value of the property at issue. And so with that, Your Honor, we move to ask for, at any point, the jury's instruction on the elements of petty theft, including intrinsic value. We clarify that intrinsic value must include a showing of at least some fair market value.
Your Honor, we'll just join that motion pursuant to Ms. Santurio's state and federal due process rights.
Well, let me ask this hypothetical. I'm not sure what the evidence will show, but let me ask this hypothetical. Let's just assume that the two chickens taken were deceased, or somehow condemned. And because of that, there's no quote-unquote market value. In other words, you can't sell it in the open market to a retail place. It can't be consumed. But Foster Farms comes in and said, hey, that's valuable to us because we can use that as compost. We can use that as in some other ways that may not have market value in the sense that the retail public would use it. That would still fall under some kind of intrinsic value, wouldn't it not?
Yeah, Your Honor, I think that would probably be fair market value for a different product. So I would probably agree that if there's some monetary value, right, that there's a fair market value, maybe not as chickens sold to consumers, but as compost. I mean, they're welcome to make that argument, and I think the jury would be entitled to find as a factual matter that that is the sort of fair market value for a different market that would lead to a conclusion that there was some value, however slight. But I think what we'd hope to avoid is a completely subjective evaluation just based on the owner's testimony. And I think we previously cited there's even a CalCrim instruction saying the owner's subjective valuation of the property is not enough. You're free to discount that. And I just am concerned that some of the witnesses are going to testify, oh, it doesn't matter how sick a chicken is, we care about these chickens and so they have some value to us. When clearly I think the evidence will present will show that these chickens were treated like garbage. They're thrown away, they're burned, they're a liability to the company, not an asset. And we don't want the jury confused about whether some arbitrary and subjective valuation by the owner somehow can create a theft or one should not have existed under California law.
All right. Mr. Colby?
Your Honor, the jury instructions under CalCrim, which have been vetted thoroughly throughout this state for a long period of time, should not be altered. That invites error when they're altered. On this issue, the jury instruction says, for petty theft, the property taken can be of any value, no matter how slight. Now, in the bench notes, it goes on to discuss certain things such as intrinsic value, which are all fair points to be argued, but the instructions themselves should not be altered. And here's an example. Let's use People versus Simpson. Defense counsel is asking for a pinpoint instruction. Let's go down to People versus Simpson at page 229. We would then ask for an instruction that is in line with this. In view of the admission of testimony as to the cost of reinstalling the magnetos, which were the items at issue here, which should have been excluded, the refusal of the court to give the requested instruction advising the jury not to consider such testimony in fixing values, because of that, and I'm paraphrasing this, because of that excluded value of it, was not sufficient. And the jury had no substantial basis to which they could fix the value of the property or find the defendants guilty of a felony. This, however, does not lead to a reversal of the case or sending of it back for retrial and adding additional costs to the county. The defendants admitted taking the magnetos and thereby admitted they were guilty of petty theft. The jury had found the defendants guilty of stealing, but we think improperly fixing the debris as grand theft, as petty theft, grand theft instead of petty theft. So there's an issue there. And then we turn to People versus Lizarraga, which actually distinguished Simpson. And it says that the defendant relied on People versus Simpson, in which the offense was reduced to a petty theft because the only evidence of value was a witness who had no knowledge of the property involved or the property of that kind generally. There's a lot of issues we boil down to. So when it comes to the issue of value, the court should follow the CalCrims. Those have been tried and tested. Adding pinpoint instructions, I think, is problematic, especially because the instructions state in the bench notes that the value doesn't have to be even to Foster Farms. It can be to anybody. So there's all sorts of, if we go down this road of pinpoint instructions, we are, number one, inviting error because we're throwing in a lot of instructions about cases that have been distinguished by other cases, and that creates an issue. They have not been vetted through the CalCrim process. And number two, we're going to have a quite lengthy and confusing instruction by the time we get through all the fine minutiae of the points. It is fair for defense counsel and the prosecution to argue points that are legally valid, such as intrinsic value. It's fair to argue that. but the instruction should remain as drafted by Calprim.
Your Honor.
Okay, hold on a second.
Sorry.
Would you, Mr. Jacoby, would you agree that value in this case should mean some monetary value as opposed to some sentimental value, subjective sentimental value?
I would disagree, Your Honor. I have pets that I love dearly, and I will tell you that I've just recently lost one, and I'll tell you that it was one of the hardest things I've ever went through. I will tell you that a lot of money was spent on that pet, and I will tell you that I don't wish that pain on anybody. I'll tell you the value to me in that situation is quite significant. Now, the monetary value, not significant. And one could argue that once she had passed away, she had no value. I would disagree with that. I don't think that.
Well, wouldn't that be a different situation? Foster Farms in this case is a commercial establishment. I'm sure they don't have sentimental attachment values to their chickens.
Aha, therein lies the problem, Your Honor. If we look at the bench notes, under value, where did I see that? Property taken must be of some intrinsic value, however slight. And the bracketed paragraph should only be given if there's a question of slight value. There's nowhere in the law that says it has to be a value to a specific person. It's just the property has to have value, and it has to be owned or possessed by another. So I would disagree with the assertion that we should start getting pinpoint instructions that it must have value to Foster Farms. I can brief that further if we get there, but that's an objection as to a pinpoint value. Then don't we buy.
Right, I understand, but is Foster Farms gonna come in and they're gonna say, all right, these chickens have intrinsic value to us in the sense of sentimental value, we have sentimental attachment value to us.
No, you're right.
I think Foster Farms says that, I think that's problematic. On the other hand, I think if the defendants say, these chickens have value for us, that's why we're involved in the case, that's a very different story, I think.
But we anticipate the evidence to show that the chickens that were taken in this case were on a Foster Farms truck, driven by a driver that was paid to drive those chickens to the Foster Farms facility. We believe that that clearly shows those chickens had value to Foster Farms, and that might actually be the extent of it.
Okay.
That's where we're at. But again, it highlights the issue of changing and altering the jury instructions that we're talking about, that we're trying to avoid here. We're trying to keep it in line with the law.
Good.
Your Honor, and just to clarify, we're not asking for an alteration to the instruction. We're just asking for an addition to the instruction based on Penal Code 44. All we're asking is the section of the Penal Code, which is the law of the state of California. It's not an addition or alteration to the law. That is cited by People v. Simpson and cited approvingly in an instruction to the jury on petty theft in People v. Simpson, be included when we instruct the jury on value. And I think we're entitled to any instruction that's an accurate statement of law that's relevant in this case.
Well, at this point, counsel, I'm gonna, we have to move on, bring the jury in, but at this point, I'm not prepared to add to the jury instruction or to modify it until we hear all the evidence. What I'm concerned about is whether some evidence will come in that are objectionable, right? So if Foster Farms comes in and testifies these have some sentimental value and nothing else, and they just testify to sentimental value, I think that's open to some objection, and the court will have to rule on that.
I don't see that as a reasonable possibility.
Okay.
I know of no such evidence.
All right, so let's stick with that, and then, if at the end you still want support to, after all the evidence comes in, you still want support to modify the jury instruction, then we can further argue on that one.
Thank you, Your Honor.
Good.
The third motion can be brief. It's a motion just to reconsider the necessity of the gag order, not the appropriateness. I think you're well within your rights. And let me just apologize again for the poor wording in the statement that was made. But I did think the transcript was very incomplete, and it was intentionally incomplete in my view, because the quote that was given, and the jury's not going to be able to hear that now because the judge's ruling, which is kind of infuriating. Clearly, when you watch the video and you see the entire transcript, the attack was not on the integrity of the tribunal, but on Foster Farms, which I think I'm entitled to say is in my First Amendment rights. Because if you continue reading, it says, just 2 sentences later, we're in a reasonable position. I'm optimistic the judge will hopefully continue to rule in a way that is reasonably fair, which I think he has so far. So I think it's clear if you just look at the next few lines, and I put the entire transcript in the briefing and a link to the video, this is not intended to be an attack on the integrity of the tribunal. There's frustration at Foster Farms' ability to conceal misconduct from the public. That was what I was intending to say. It came out poorly, and I apologize to Your Honor for that. But partly for that reason, and because the video, even as recently as yesterday night, which I checked again, only has 229 views on an animal rights YouTube page, I think the odds that anyone in Merced County has viewed this video are very small. And so, showing that there is a substantial likelihood of materially prejudicing an adjudicated proceeding when there are only 229 views on a video on a global website, YouTube, are very low. Now, again, we agree that Your Honor has the authority to issue the order that you issued. I just think that the grounds upon which it issued are probably not apparent, to me at least, from reading the prosecution's brief, and therefore I think the necessity of the gag order is in question. But I'll leave it in Your Honor's hands. I just wanted to clarify the record.
And Your Honor, if I may respond, I'm
Yes.
going to ask the court to issue a finding that there was no intentional misrepresentation by the people. The defense counsel's motion states that the people made material misrepresentations. They do not at all reflect the fact that we made it very, very clear to the court yesterday in viewing the statement as a whole. We do not find it to be an attack on the integrity of the court. We only objected to the fact that defense counsel was reciting publicly through this media source evidence that had been excluded in a specific fashion. The quoted part was the objectionable part, where defense counsel stated the jury's not going to hear this evidence, then recited what the evidence was, then closed it by saying, and the jury's not going to hear that evidence. Now, in terms of likelihood, question is there a serious and well-founded risk that the jury could in fact hear that? Now, an average Merced County citizen who has nothing connected to this trial whatsoever, I would agree that'd be extremely slight. But my concern is, as much as we demand jurors follow the law, curiosity sometimes can get the better of them. They might do a Google search and find this video. If they find this video, they're going to hear a statement of what's going on. Now, it's more likely that somebody who's connected with this case, such as counsel for the prosecution, have both seen the video, where 2 of the views are right here. It's more likely that people that are connected with this case will in fact view it. And I worry that a juror might inadvertently look it up, and it's been known to happen. This is highlighted by the fact that after bringing this motion yesterday, one of the jurors mentioned seeing coverage of this case on Inside Edition, which, you know, there's coverage out there they're going to have to watch, and I applaud that juror for doing the right thing and turning away from it. But I worry about curiosity being piqued such that a juror might do something that the court has said not to do, which is go look for public information and find that. And that's why the order should remain. But in addition, I'm asking for a court's finding that there was no intentional misleading on behalf of people. I do take issue with the written citation of material representations and the verbal citation that we were being intentionally misleading in seeking this motion.
Okay. Well, the court's order is, if the court recalls, I don't have it right in front of me, but it's narrowly tailored to issues that are evidence that have been not yet admitted, or evidence that have been excluded. Counsel not to discuss those evidence within, and so the order will remain as is. And the court does make that finding that there was no intentional misrepresentation by people. Okay. Anything else? Let's bring in the jury. Okay. Do we have wireless mic working? If you have any PowerPoint, where those are plugged in and ready to go?
In the Superior Court of the State of California and in Forth County, Merced, the people of the State of California, plaintiff versus Alexandra Paul and Alicia Santurio, defendants. Case number 22 CR 01899 A and B, criminal complaint. The District Attorney of Merced County, California hereby accuses the above named defendants of the following criminal offense occurring in the County of Merced, State of California. Count 1, Penal Code 484, subsection A, petty theft misdemeanor. On or about September 28, 2021, Alexandra Paul and Alicia Santurio did unlawfully steal, take, and carry away the personal property of another, to wit, Foster Farm. Nicole Silvera, District Attorney, signed by Joseph Attwell, Deputy District Attorney, to which the defendants have entered pleas of not guilty.
All right, thank you. All right, as I was saying, the people may present an opening statement. The defense is not required to present an opening statement, but if it chooses to do so, it may give it either after the people's opening statement or at the beginning of the defense case. The purpose of an opening statement is to give you an overview of what the attorneys expect the evidence will show. Next, the people will offer their evidence. Evidence usually includes witness testimony and exhibits. After the people present their evidence, the defense may also present evidence, but is not required to do so. Because they are presumed to be innocent, the defendants do not have to prove that they are not guilty. After you have heard all the evidence and before the attorneys give their final arguments, I will instruct you on the law that applies to this case. After you have heard the arguments and instructions, you will go to the jury room to deliberate. Our system of justice requires that trials be conducted in open court with the parties presenting evidence and the judge deciding the law that applies to the case. It is unfair to the parties if you receive additional information from any other source because that information may be unreliable or irrelevant. Your verdict must be based only on the evidence presented during trial in this court and the law as I provided to you. During the trial, do not talk about the case or about any of the people or any subject involved in the case with anyone, not even your family, friends, spiritual advisors, or therapists. Do not share information about the case in writing, by email, by telephone, or on the internet, or by any other means of communication. You must not talk about these things with other jurors either until you begin deliberating. As jurors, you may discuss the case together only after all the evidence has been presented, the attorneys have completed their arguments, and I have instructed you on the law. After I tell you to begin your deliberations, you may discuss the case only in the jury room and only when all jurors are present. You must not allow anything that happens outside of the courtroom to affect your decision. During the trial, do not read, listen to, or watch any news report or commentary about the case from any source. Do not use the internet in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. If you have a cell phone or other electronic device, keep it turned off while you are in the courtroom and during jury deliberations. Any electronic device includes any data storage device. If someone needs to contact you in an emergency, the court can receive messages that it will deliver to you without delay. During the trial, do not speak to a defendant, witness, lawyer, or anyone associated with them. Do not listen to anyone who tries to talk to you about the case or about any of the people or subjects involved in it. If someone asks you about the case, tell him or her that you cannot discuss it. If that person keeps talking to you about the case, you must end the conversation. If you receive any information about this case from any source outside of the trial, even if unintentionally, do not share that information with any other juror. If you do receive such information, or if anyone tries to influence you or any juror, you must immediately tell the bailiff. Keep an open mind throughout the trial. Do not make up your mind about the verdict or about any issue until you have discussed the case with the other jurors during deliberations. Do not take anything I say or do during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. Do not let bias, sympathy, prejudice, or public opinion influence your decision. You must reach your verdict without any consideration of punishment. I want to emphasize that you may not use any form of research or communication. including electronic or wireless research or communication, to research, share, communicate, or allow someone else to communicate with you regarding any subject of the trial. When the trial has ended and you have been released as jurors, you may discuss the case with anyone. You have been given notebooks and may take notes during the trial. Do not remove them from the courtroom. You may take your notes into the jury room during deliberations. I do not mean to discourage you from taking notes, but here are some points to consider if you wish to take notes. 1, note-taking may tend to distract you. It may affect your ability to listen carefully to all the testimony and to watch the witnesses as they testify. And 2, the notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. At the end of the trial, your notes will be collected and destroyed. I will now explain to you the presumption of innocence and the people's burden of proof. The defendants have pled not guilty to the charges, or to the fact that a criminal charge has been filed against the defendants are not evidence that the charge is true. Okay? You must not be biased against the defendants just because they have been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Prove beyond, whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendants guilty beyond a reasonable doubt, they are entitled to an acquittal, and you must find them not guilty. You alone must judge the credibility or believability of the witnesses. In deciding whether testimony is true and accurate, you must use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are: how well could the witness see, hear, or otherwise perceive the things about which the witness testified? How well was the witness able to remember and describe what happened? What was the witness's behavior while testifying? Did the witness understand the questions and answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in the case, or a personal interest in how the case is decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? And did other evidence prove or disprove any fact about which the witness testified? Do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what they remember. Also, two people may witness the same event, yet see or hear it differently. If you decide that a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things, but told the truth about others, you may simply accept the part that you think is true and ignore the rest. If, during the trial, you have a question that you believe should be asked of a witness, you may write out the question and send it to me through the bailiff. I will discuss the question with the attorneys and decide whether it may be asked. Do not feel slighted or disappointed if your question is not asked. Your question may not be asked for a variety of reasons, including the reason that the question may call for an answer that is inadmissible for legal reasons. Also, do not guess the reason your question was not asked or speculate about what the answer might have been. Always remember that you are not advocates for one side or the other in this case. You are impartial judges of the facts. You may be permitted, and you are permitted, to separate during recesses and at the end of the day. I will tell you when to return. Please remember we cannot begin the trial until all of you are in place, so it's important to be on time, which you have been. So I thank you very much. I appreciate that. Remember, do not talk about the case or about any of the people or any subject involved in it with anyone, including the other jurors. Do not make up your mind about the verdict or any issue until after you have discussed the case with the other jurors during deliberations. All right. At this point then, I'm going to open it up to the attorneys to present the opening statements, and the people may go first.
Your Honor, many apologies, I should have requested this before you begin the instructions, but is there going to be a sequestration order in this trial before opening for witnesses?
Oh, motion to exclude?
Yeah, motion to exclude all witnesses?
Yes.
I believe there was one
Yeah.
in my motions
Okay,
eliminated.
we have not heard, but the motion is granted. There anyone who's going to testify in this case? Okay, if you are, you would have to step outside.
And Your Honor, that will include the expert witnesses as well?
Yes,
Okay, great. I just want to make sure we're all on the same page.
okay,
Thank you, Your Honor.
thank you. All right. Okay, Ms. Attwell?
Truck. That truck was contained chickens, which belonged to Foster Farms, and that truck was headed to a Foster Farm facility in Livingston. I expect them to show that they ran in between in the cab of the truck and the trailer, pulled down a metal shutter, grabbed two chickens, and then ran to a car or stopped behind the truck. I expect you to hear from the driver of that truck, and I also expect you to hear from several defense witnesses. However, once you have heard all the evidence and have all the facts, that's the only reasonable conclusion you'll be able to come to those from those facts is that the defendants intentionally took something from Foster Farms, and that they are guilty of petty theft. That is it. This is a simple case. Thank you.
Mr. Hsiung?
Your Honor, I'll reserve my opening for the beginning of the defense's evidence.
Okay, defense reserved this morning. Mr. Martin or Mr. Carroll?
Yes, Your Honor, on behalf of Ms. Santurio, we are ready to give our opening.
You may.
Thank you. I think we need to, I'm representing Alicia Santurio along with Chris Carraway. Caring for chickens that are desperately ill and have been subjected to abuse is not a crime. Rescuing those chickens when they face a certain death, either in a trash bin or on the floor of a slaughterhouse, is not a crime.
Objection, Your Honor. May we approach?
Go ahead and state the basis of the objection.
Violation of motion to eliminate. One of the motions eliminate, Your Honor.
Okay, go ahead, bro.
Mr. Little, you may proceed.
Thank you, Your Honor. As I was saying, the evidence is going to show that the two defendants reasonably believed that what they were doing, rescuing animals that were sick and facing certain death, was not a crime. Before I go further, let me explain the context in which these events occurred. There are chickens, there were two chickens that were rescued in this case. One was named Ethan and one is named Jax. These chickens were at a farm. It's called that euphemistically. It's really a holding facility where young chickens are fattened up in filthy conditions before they're loaded on a truck and transported for slaughter. These chickens are taken at approximately when they're less than 4 months old, and they're slaughtered. The evidence will show that there is little, if any, attention paid to any individual chicken. Foster Farms has an algorithm that they rely on. As long as a sufficient number of healthy chickens make it to the end of that process, what happens to those that are not sick, that are not healthy, matters little, matters not. Alicia Santurio and Alexandra Paul, who also was on trial, they knew that. They knew that from, in Ms. Santurio's case, first-hand experience. She had been to foster farms. She had seen firsthand the conditions. She had seen that the chickens were in conditions that very likely would result in many of them being sick. She saw that, and she also drew upon her lifetime of experience dealing with chickens. You'll hear evidence in this case that Ms. Santurio can recognize very easily when a chicken is sick. There are very obvious signs of that. And you'll hear that Ms. Paul was also educated in that manner. So these defendants did not act on a whim when they did what they did on the 28th of September 2021. And let me just make clear, the defendants in this case, yes, they are animal rights activists, but they did not act on the position on the 28th of September 2021 that they were attempting to save all the chickens. They respected Foster Farms' right to slaughter their animals. But sick animals, you'll hear, pose a great danger, not just to the poor birds, but also to the public. These animals, who spend the 4 months of their short life rooting and sometimes even eating their own excrement around other sick birds, when they get to the slaughterhouse and they're seen by people who can equally well recognize them as the sick birds that they are, they typically die a miserable death, thrown on the floor or in a trash bin to slowly suffer and die. You'll also hear that if they're not recognized as unhealthy birds and they're taken to slaughter, these birds can carry what are called zoonotic diseases, diseases that can pass from animals to humans. And we all know about that from what we've lived through in the last 3 years. That those can affect the public. So that's the backdrop in which what occurred. I think it's also worth understanding that the defendants did not act precipitously. Having the knowledge that they possessed, they contacted public authorities and asked for something to be done. They contacted the Attorney General, they contacted the District Attorney, they contacted local law enforcement. They waited. Nothing was done. So then they relied on the advice of an attorney and a law professor who essentially told them that if you reasonably believe that you are dealing with birds that are being abused, because even animals who are being taken to slaughter have a right not to be abused. And I think the best analogy for that is we have in some states still the death penalty in this country, but you have to kill the person in a humane way, not by torture. It's the same with animals. So if you reasonably believe that animals are being tortured, abused, and if you reasonably believe that there is also a threat to the public.
Objection, Your Honor. No reproach.
Thank you, Your Honor. So you hear that Ms. Santurio and Ms. Paul received advice from a legal scholar that said, under the circumstances that were outlined, a citizen who cares about animals and who cares about the public has a right to rescue those animals. And even then, they didn't act precipitously. As I indicated, there was an attempt made to contact public agencies, including the district attorney. So by September 28th, Ms. Santurio and Ms. Paul reasonably believed that the choice was to do nothing or to act. And they decided to act. And this whole incident, which I think spans some 45 or so seconds, is on video. And as part of my opening presentation, I want to show you that video.
Sorry, I just need to get the audio.
I got it, Alicia, I got it, go. Sure. We got it, we got it, we got it.
What you've just seen is why we emphasized during the selection process that this case is not to decide the what happened or the who done it. This case is about the why. With respect to the why, as I've already indicated at some length, the evidence will show that Ms. Santurio and Ms. Paul reasonably believed that they had the right to rescue those animals for the protection of those animals and also for the protection of the public. And you'll also hear evidence that there are suspicions that the two birds that they selected out of that one area which had multiple birds. Their suspicion that those birds were sick was correct. The two birds, one, as I indicated, Ethan, and the other, Jax. Ethan, within approximately 3 days, died from the illnesses that he had when he was loaded on that truck. And something called a necropsy was done. Necropsy is an autopsy that's done on an animal. And you'll hear about the results of that necropsy, which showed that Ethan had numerous illnesses, not just one, numerous illnesses, which very likely would have resulted in his being cast aside once he reached the slaughterhouse and dying a slow, miserable death. You'll also hear that some of the illnesses that Ethan had were potentially zoonotic. Again, capable of being transmitted from animals to people. You'll hear that there was no intent to profit. There was no intent to deprive foster farms of anything of value. Indeed, animals, you'll learn in this case that animals that are sick, such as what these two poor birds were, they're not even supposed to get on the truck because of the risk of infection of other birds. It violates basic public health rules. You'll also hear that as a result of the two defendants removing those two sick birds, that was an act that didn't cost foster farms anything. As a matter of fact, it potentially saved them money. It potentially saved them from the liability that could have been incurred had those birds infected other animals, or if they had been consumed and made a human sick. With respect to this incident, you'll hear and you'll conclude at the end of this case that neither Ms. Paul nor Ms. Santurio had any desire to keep these animals for any business reason, for any monetary reason. Ms. Paul and Ms. Santurio are not from Livingston. They went there at their own expense, financial loss. They cared for these animals, and people who were also with them, supporting them, spent money caring for these animals on the necropsy. This was not a financial plus for them. They did this to rescue animals because they had been told by someone who they reasonably believed knew what he was talking about, that they had the right to rescue. Now, no one likes to have their wrongdoing brought out, right? Who likes to be called out? No one. But just because you're called out by people who felt that it was their civic duty to do what they did, doesn't mean that it's okay to prosecute them and thereby attempt to silence them.
Objection, Your Honor.
Listening.
At the conclusion of this case, you're going to hear, after you've heard all the evidence, you're going to see that both Ms. Santurio and Ms. Paul reasonably believe in their heart of hearts, in good faith, honestly, that they had a right to rescue these birds. And if you conclude that, the only verdict that will be warranted by the evidence is not guilty. Thank you.
All right. Thank you, Mr. Lowe. People may call the first witness.
We've already called the first witness, although does the court have the